Hello, my name is Cristina Blasi, and I will briefly explain to you the main aspects on data protection in the European Union. So basically, in the European Union, we have as a main piece of legislation the General Data Protection Regulation. And this is a regulation that is in force since 2018. The material scope of this regulation is any processing of personal data in the European Union for any purpose, mostly commercial, but not only, except for data that is processed by law enforcement authorities, which they are bound by another piece of legislation, which is a directive. And data processed by intelligence services is also not covered because it's considered that this falls under the scope of the member states. National security issues belongs to the member states to regulate. The European Union cannot interfere. So this general data protection regulation does not apply for that. As far as the territorial scope, this would affect companies based in the European Union, but it also has the so-called extraterritoriality. So that means that also companies based outside the European Union, but processing personal data from EU citizens or EU residents, and also companies outside the European Union, but monitoring the behavior of EU citizens or EU residents will also be compelled by this regulation. And this regulation basically establishes really high standards in terms of the protection of personal data. Let me just, explain to you one example, which is the right to be forgotten. The right to be forgotten means that you can erase your data forever, as far as it is possible, because as we know in the internet, we are never 100% certain that our data will be completely removed from everywhere. But at least legally, we can claim that. And this person in the picture is actually the person that first fought against this possibility. He's Mr. Costeja, which opened the case against Google because he found that Google was indexing a piece of information from him from years ago that was saying that he had some debts that he no longer had. And that was really affecting his reputation. And whenever he would contact the source of that information, which was a newspaper, the newspaper was saying, we have no obligation to remove that information because we are a newspaper, so we inform people, and that's our fundamental right. And whenever he would go to Google asking for de-indexing that information, Google was saying, we are not the ones responsible for it. We are only indexing. We have no obligation to monitor everything that we index. So we don't have the obligation to remove that information. The case arrived into the Court of Justice of the European Union that was interpreting whether search engines do actually have responsibility of the information in their indexes, and if they are in some cases obliged to remove that information from these indexes. And the response was yes. The Court of Justice considered that search engines are actually data controllers. So they have the responsibility of the information. They have the capacity to remove, to de-index information from their indexes. So in that case, when the information is no longer relevant, is not accurate, the person is not a public person, so there is no need to really inform about this person to the world. So all these checks were complied by Mr. Costeja. So finally, it was decided that he had the right to be forgotten. And that was later incorporated again as well in the General Data Protection Regulation as a right. Also, I would like to briefly explain to you that the General Data Protection Regulation has a few provisions related to international data transfers. So data that it's transferred outside the European Union. And this could be very easy or very difficult. It is very easy when there is what is called the adequacy decision. So when there is a decision made by the Commission that says, okay, this third country has similar standards as the GDPR, so there's no problem in transferring data back and forth. And there is a list of countries which have these adequacy decisions, for example, Andorra, Switzerland, Japan, the UK. So for those countries, the transfer is automatic and there is no need for authorization, no need to wait for anything. When the country is not in that list, then the things are a little bit more complicated. And then one option would be, for example, if you need to transfer that data outside the European Union to, let's say, Mexico, then one possibility would be to sign the so-called contractual clauses, which is fundamentally it's a contract already provided as a template by the Commission that establishes the obligations that have to be enforced and have to be taken place when this data transfer happens from the importer, but also from the exporter. There is all these limitations and obligations that need to take place. And this has to be signed. If there is any modification of the template, it has to be authorized by the data protection authority of the country in the European Union that is sending the data. And that's one option. Another quite common option is to sign the so-called binding corporate rules. And the binding corporate rules is normally the option chosen by those companies that have, let's say, a headquarters in one country in the European Union, but then several subsidiaries outside the European Union. What happens when they have to send back and forth data among their offices? Well, they will probably sign binding corporate rules, which is similar to the contractual clauses, but more tailor-made to that particular company and to that sector. And once they have drafted the potential contract with the standards that they will apply, this has to be authorized by a data protection authority in one of the member states. So this is another option to transfer data abroad. The case of the United States is quite interesting because for the first time since 2023, there is an adequacy decision in place through an agreement that was signed. It's called Transatlantic Data Privacy Framework that was trying to really reach the same standards as the GDPR. So now with the adequacy decision, the data transfers between the two countries is also very easy, it's automatic. Before we arrived to that very important milestone, there were several agreements in the past, but these were not finally working. They were annulled by the Court of Justice. Right now, we have in force a framework that allows data transfers between the two territories without any kind of authorization. So that's all from my side, and thank you very much for your attention.